Our top story. There was a time when investigations were thorough and cases were watertight. Not anymore. Nowadays, most people can guess how investigations will pan out. Summon, interrogate, arrest. That's the new formula being used by agencies like the CBI and the Enforcement Directorate. What's worse is that trial courts are playing along. Instead of granting bail, these courts are remanding the accused and extending their custody. On Tuesday, the Supreme Court came down heavily on this practice. The court was hearing a petition seeking anticipatory bail by an accused who feared arrest by the CBI. The top court had tough words for both the trial courts and the agencies. It observed that some judges were passing detention orders in a routine and mechanical manner and thus denying liberty to the accused. The court said such judges should be removed from the system and sent back to academies for upgrading their knowledge. The court also warned that agencies like the CBI and public prosecutors will be hauled up if they unnecessarily oppose bail in courts. Last year, in July, the top court has issued explicit instructions to lower courts and agencies. Bail, not jail, should be the norm, they said. It had asked agencies to not arrest people who are cooperating with the probe in cases of offences where the maximum jail term is 7 years. It had also asked lower courts to protect the liberty of the accused. But yesterday, the Supreme Court observed that its order was being violated over and over again. It also asked high courts to ensure that judges who violate the Supreme Court order are withdrawn and sent back to law academies to learn the basics. Now, if you think back to last year, the top court had spelled out clear instructions for agencies and lower courts. The courts had clearly said, and let's put that out on our screens for you, arrest is a draconian measure and should be used sparingly. Bail is the rule and jail is the exception. That was the instruction from the Supreme Court. But if you look at recent cases, the exact opposite is happening, despite the Supreme Court's repeated warnings in the last 1 year. People are being arrested even if they are cooperating with investigations. And lower courts are playing along and rubber stamping these arrests. Let me show you a list of political prisoners who have been victims of this trend. Sanjay Raut, the Uddhav Sena leader who was in jail for 5 months. He was arrested by the ED on charges of money laundering. The lower courts ended up extending his custody. In Delhi, Satyendra Jain, former minister, he was also arrested by the ED in a money laundering case. Now, Mr. Jain has been in jail for more than 10 months. Another example is former West Bengal minister Partha Chatterjee. He was arrested in the teacher recruitment scam and is yet to be given bail. It's been more than 9 months since his arrest. Example number 4 is Nawab Malik, former minister in the Maharashtra government. He was arrested in a money laundering case by the ED and he spent almost 14 months in jail. Again, Anil Deshmukh, Maharashtra, former Home Minister of Maharashtra, spent 1 year, 4 months in jail. He was arrested by the ED in a money laundering case. And finally, we have former Home and Finance Minister P. Chidambaram. He spent 106 days in jail over the INX media foreign funding case. The latest, of course, you know him, Manish Sisodia. Today, his judicial custody was extended until April 5th. Now, not for a moment am I saying that these leaders are guilty or not guilty. I don't know that. I'm not the court. And even the courts will know only once the trial takes place. But here's the thing. None of these leaders were a flight risk. Some of them were sitting and former ministers. These are people who occupy respectable positions in our society. The question is, what was the need to keep these people in jail for so long when they were cooperating with the probe? And more importantly, why did lower courts play along? If this is the treatment that is reserved for VVIPs, question is, what chances does the common man have? Let me get you some numbers on that question. 77% of all prisoners in Indian jails are under trials, meaning they have not been found guilty. They are awaiting trial. In terms of absolute numbers, there are more than 4,20,000 under trial prisoners in India. Many of them are first-time offenders accused of petty crimes, minor crimes. 5,000 of them have already got bail, but they are too poor to complete the bail proceedings. So the Supreme Court has come up with a solution. Since 2023 is the 75th year of our independence, let off prisoners who are first-time offenders and accused in petty crimes. The court says take a personal bond of good behavior and let them walk out. The court believes that such innovative ideas are needed to declog the system, to declog our jails and the judicial system as well. Just to give you an idea, there are more than 4 crore cases pending in our lower courts. And like I mentioned, around 77% of all prisoners are under trials. Most of these prisoners are poor and illiterate. They are burning through their life savings and their life as they wait trial in jail. So the top court wants to let off these people who are accused of minor crimes. Can that solve the pendency problem? Perhaps it can, but it still doesn't solve the problem of bail, not jail. And that is something we are talking about. Why is there such judicial inconsistency when it comes to bail? And why, despite the Supreme Court's repeated reminders and warnings and scoldings, trial courts insist on putting people behind bars? 3 legal eagles are joining me this evening for a very quick chat. We promise not to make this a complicated legal discussion. The question we raised today is one of personal liberty. So that is as personal as it gets. It impacts you. So we are urging you to stay on with us. Let me introduce my guest to you. Sanjay Hegde is a senior advocate joining us on the broadcast. Namit Saxena, again, an advocate with us on the show, and Aditya Singh is an advocate as well. Sanjay Hegde, I want to start with you, and I want to understand from you that if the cornerstone of Article 21 is personal liberty, bail, not jail, why is it so hard for trial courts in this country to accept it and act accordingly? Yes, I understand there is an element of discretion involved, but this discretion also has to be guided by law. And the Supreme Court over and over again in the last 1 year has told us what the law is. So what is the problem?
Well, the same Supreme Court in some other judgments dealing with money laundering and UAPA has made the law of bail so very tight that courts just can't give it. Now, let me just explain to your viewers what money laundering is. Money laundering is if you commit a crime, you take the proceeds of the crime and then legitimize that money by layering it through other agencies and all that and making it something. So what happens, and the Money Laundering Act has some very specific sections which says that the court can't grant you bail except if it believes that you are not guilty and that you will not commit another crime and that the prosecutor has to be heard. So those sections have been interpreted by the court to say that no, almost once there's an allegation of money laundering, then there's no question. You have to go through a full trial and only then grant bail. So while the Supreme Court is naturally conscious of being a sentinel on the qui-vive as far as fundamental rights of the citizens are concerned, the same Supreme Court has at times been more executive-minded than the executive. And what these laws do is to basically enable a police officer to throw a person in jail, and then courts which are not the Supreme Court tend not to grant bail for mere fear that somebody will say that, no, look, this man abused his discretion. You had this classic case of Aryan Khan, Shah Rukh Khan's son. The allegations were ridiculous. And the other co-accused got bail from the trial court itself. But in the case of Arya Khan, it needed a full hearing to go to the High Court. In the meanwhile, the boy was in jail. And finally, the High Court granted bail mercifully. But many of these people who you are putting out on the on your video, most of them are accused under money laundering, and conditions for bail there are very, very different. There is, even if the Supreme Court keeps saying that bail, not jail, most courts, especially the trial courts, operate on, well, stay in jail and then let me decide my discretion. And I won't exercise it very easy.
Okay. So are you in a sense, I'm not saying accusing is a big word, but are you accusing the Supreme Court of doublespeak then? Is that what you're saying, Mr. Hegde? That on one, one side you're tightening the law, on the other you are saying bail not jail, bail not jail, bail not jail.
You see, the point is that there is no one Supreme Court. There are several benches of the Supreme Court. And though there is an overarching kind of desire that we protect the liberty of people, equally, whenever the government makes a very harsh law, courts rush to uphold it. There must be certain minimum standards of defending liberty. And if you see harsh laws being promulgated, then it becomes incumbent on constitutional courts to strike down those harsh laws and ask difficult questions of the administration. That is where I don't see enough leadership coming in. If all the courts in the Supreme Court were to say, yes, we will all say only that we will lean towards bail and we will encourage the courts below to grant bail, then you're likely to have different results. Right now, there are contradictory voices.
Okay, so you're saying the Supreme Court has spoken in different voices. Therefore, there is a judicial inconsistency granting bails when it comes to the trial court. Aditya Singh, do you agree with that? The Supreme Court sounded very anguished in what they said yesterday about bail. They're saying, we're telling you over and over again, if trial court judges do not want to listen, maybe they need to be taught the basics of law and sent back to law school. So the Supreme Court sounded very anguished.
The comments may have been a little scathing in nature, but I might, going by my personal experience of over 10 years, I might not subscribe too much to them. I do feel that the trial courts are well equipped to decide to whom to give bail, to whom not to give bail. In fact, it is my observation that trial courts, especially when do not give bail, when it's a matter of serious offenses like murder, like rape, grave offenses against the human body, where the accused is well connected, where he can influence witnesses. Today we saw how Atiq Ahmed got a witness bumped off while he was in jail. So trial courts, in my opinion, based on my experience in day-to-day hearings, are quite well equipped to decide which cases to give bail, which cases to not give bail. Yes, there might be a few exceptions, like, for example, if you see an offense like Makoka. In Makoka, of course, the courts have to be a little more sensitized because I believe, like, for example, in an area like Makoka, the Maharashtra Control of Organized Crimes Act, trial courts are usually reluctant to grant bail. But again here, the trial courts, probably they might not be in a position, they do not adequately distinguish which is a put-up case and which is an original case. But by and large, when I look at the bigger picture, I certainly would not agree with the view that the judicial officers have to be sent back. In fact, I honestly feel that the judicial officers who preside in the trial courts are the foot soldiers of justice. And I would say that even the judicial officers of the magistrate and the trial courts and the sessions courts, they do an excellent job when it comes to dispensing justice and when it comes to deciding which cases to give bail and not to give bail. Let us look at money laundering offenses. Okay, you might say that the PMLA Act is misused, that the ED is committing excesses. But the fact remains, look at these major bank scams. Thousands of crores of depositors' money vanishing down the drain. Recovery is 5 or 10%. In fact, one chief consideration why courts do not grant bail in such matters is because, in the opinion, recovery of money is important. Of course, while there are matters under investigation, and these matters tend to be under investigation for long periods, 1 year, 2 years. So the courts do feel that custodial interrogation is necessary to uncover the money trail, which goes into multiple different directions.
But Aditya, let me take an example. For the benefit of our viewers, I just want to keep it really simple. For the benefit of our viewers, and this is just an example I'm taking because something regarding it has happened today. Manish Sisodia, for example. Why is the court not giving him bail? He's cooperating with investigations. What is the evidence that you have found against him? Precious little. He was a sitting minister till a little while ago in the Delhi government. So he's not a flight risk. Why arrest him? Why not give him bail? Forget arresting him. Why not give him bail?
No, see, first and foremost, the point is these are alleged offenses of corruption and bribe taking. Now you're well aware.
Correct.
How in 2G scam also several of the accused got acquitted, if you remember the 2G judgment. Now you must understand that in such cases of bribery and corruption, the bribes are given in a very surreptitious manner, and the investigator has to be, it's not someone who's going to walk into Manish Sisodia's office, give a suitcase of money and say that here, frame the liquor policy as per my convenience. No. In fact, liquor policy is meriting a detailed investigation, because while the irregularities are the face of it, to prove the nexus between the beneficiaries and the accused, the investigation requires, because how the money changes hands, how the investigator has to go the extra mile. So obviously the courts, when they exercise their discretion, they will be keeping these factors in mind, that an offense like corruption requires extra investigative effort and mere factum. What do you mean by cooperate with investigation? See, the point is, no accused person can be compelled to incriminate himself. It is a constitutional bar. So obviously, we cannot expect money, to expect that cooperation with investigation would amount to admitting that he did some wrongdoing acts. No, that is not the case. A full money trail has to be uncovered. The full trail of quid pro quo has to be uncovered. And what the trial court solves also with the fact that several high and mighty accused are involved in this matter. So yes, if a trial judge is, remember, a trial judge is always prefers to be on the point of caution. He wants to ensure that the maximum possible evidence comes to light, that the investigation is complete in all respects. And yes, in cases of heavy offenses of corruption, major frauds, where huge pecuniary considerations are involved, they would be treated on a slightly a different footing vis-a-vis regular cases.
But, but Namit, such a great degree of caution, where you have completely clogged the jails. Forget the judicial system, look at our jails. Such a huge degree of caution. Essentially what both the gentlemen before you have argued, that trial courts have a discretion, that it is there for a reason, let them exercise it. Where do you stand on this debate?
Have a discretion, but every discretion is to be judiciously exercised is one. Second, as Mr. Hegde pointed out, see, these laws are draconian in nature. Section 45 of the PMLA and Section 30 on the NDPS Act, it is almost difficult by the interpretation given by the Supreme Court for the trial courts to grant a bail, accused in these cases actually is one. Second, there is an entire bail cancellation jurisprudence also developed by the Supreme Court. Not only the interpretation of these, stringent provisions, but also, the Supreme Court has multiple judgments, particularly, a particular judge, sitting judge of the Supreme Court, he has developed this entire jurisprudence where the trial courts or the High Court, they grant bail in, particular cases. The Supreme Court cancels that bail, saying that, that this has been granted in a mechanical or a casual manner, and all the relevant factors, all the eight or nine relevant factors which are to be considered have not been considered properly in my view, and therefore I'm cancelling the bail, is one. Second, the Supreme Court also, as you said that, the jails are congested. Supreme Court tried to evolve a jurisprudence of house arrest in few particular cases. But again, that has not developed as a jurisprudence completely, because that has also remained judge-centric and it is not principled in nature. Few judges, tend to grant house arrest using few judgments of the Supreme Court. Few judges, as Mr. Hegde also pointed out, there are 17 odd, different benches of the Supreme Court. Few judges, throw those judgments outrightly. They don't even look at it. So, so we have a very judge-centric outlook towards, how we grant or how we deal with personal liberty in this country. If this matter, Satyendra Kumar Antil's matter would have been before another bench would have, perhaps looked at it from a complete, point of view, and they may have perhaps encouraged the trial courts to not grant bail in certain cases. So this is highly judge-centric. Bail has to be principled, and there is a suggestion which has been made by the Law Commission also that there has to be a separate bail code altogether, where somebody's personal liberty is curtailed by the state. That accused or that citizen of the country knows what is going to happen to me, instead of just languishing behind the jails. So see, it's mixed actually. The observations made by the Supreme Court. Jail is, the exception. Jail is the rule in certain cases. Certain cases, the law is such that this principle cannot be squarely applied. And third is that even if the trial courts or the high courts apply this principle, the Supreme Court cancels the bail. So, this observation which the Supreme Court has made, yesterday, this observation is to be taken with a mixed, view from both perspectives. Mr. Aditya Pratap is also not completely wrong in saying that, that there are so many, that there are scams altogether, in which, jail is actually, in some sense required. In fact, I'll tell you a personal experience where a particular murder accused, was granted bail by the High Court. He went out, he, murdered the complainant. He was eventually, after 2 odd years, granted bail. And that complainant's murder, he went, out again and he murdered the eyewitness, in that complainant's case. There's a triple murder case now. Now the High Court has said, no, sorry, we can't keep granting you bail because you go out, you commit murders and then come back. So all these factors, they're ground realities. Caste equations are there, regional equations are there, region equations are there. So all these factors, the trial court is more, because it's on the ground level, the trial court knows it better. So to, simply give a blanket order and say, that the trial courts, the judges, because they're discharging their duty responsibility to the best of their abilities and knowledge, that they should be sent back to judicial academies to have their lectures and training again. If they don't, follow their discretion as per, as we advise them to have exercise their discretion, this is not completely correct to say. So my reaction is mixed. To what the Supreme Court has ordered yesterday.
Okay. So essentially, it's interesting what I hear all three of you saying. What I hear all three of you saying as a non-legal person is this, that the Supreme Court can say what it wants to say, but there is a discretion that the judges have, trial judges have, and they have it for good reason. Let them exercise it. One of the examples that has been given by Namit, which perhaps explains, Sanjay Hegde, the judicial inconsistency while granting bail. For example, Munawar Farooqi will not get bail. For example, Siddiq Kapan will not get bail, but Arnab Goswami will get bail. The cases are almost the same, similar cases, similar arguments, but there are some people who will get it, some people who will not get it.
That's the sense of tyranny, isn't it? Show me the man and I'll show you the law. So that really is the problem. There are some cases, there are some people who are bail worthy and some who are considered to be unworthy of bail. So the real thing is that as a country, we should take it upon ourselves to say that liberty in our country is sacrosanct. If you have to take away somebody's liberty, maybe the person is facing a grave accusation, but it is still an accusation and you have to prove it beyond all reasonable doubt before you take away liberty. So if you are going to jail someone, if you probably put the onus upon the person seeking to jail, that is the investigating officer, then possibly you will have less of a police state than what you currently have. Today, as the law stands, if a policeman decides to accuse you under money laundering or NDPS or any of these tough laws, then there is very little that the courts can do to examine, except to hold a full trial, which is almost impossible given the amount of cases which are pending in court. So what happens is that liberty becomes then subject to the availability of judicial time. Investigators know that the courts just can't afford that time. So they can very well pick and choose, and that somebody whom they don't like or a particular family whom they don't like, they'll lock them up and throw away the key. For example, you spoke of Manish Sisodia. There was a possibility that in the main corruption case that he would get bail. Then no sooner was that possibility there that the ED also stepped in. So it's like a double jail, and you have to cut through with separate bail orders in each case.
And in the process becomes the punishment, as it were. This was a good chat. Thank you so much. This was an important chat to have. I'm glad you guys didn't keep this complicated. So thank you very much for that as well. Sanjay Hegde, thank you for joining us on the broadcast. Namit, good to have you on the show. Aditya, good to have you on the show as well. I'm slipping into a quick break on the show with that. Our other stories coming up from Uttar Pradesh. It's a story that all of us need to listen to. For the moment, a quick break.